Hi, welcome to CCI Huronia's first webinar. We have people from all across the province joining us today, so we welcome all of you, and we're very excited to be doing our first webinar for CCI Huronia on COVID. My name is Sonia Hodis. I'm one of the many directors at CCI Huronia, and I'm also a condo lawyer. We have many speakers with us today, all of who are members of the CCI Huronia Board of Directors, and we're very lucky that they've taken the time over the last week to help get this seminar prepared for tonight. COVID-19 has taken not only our condo communities by storm, but we find ourselves grappling with many new issues that we've never experienced before or planned. In addition to our condo community itself, we find our schools closed, non-essential businesses are now being forced to close, provinces and cities have declared states of emergency. And in the midst of all this chaos, we really have very little, if any, precedent on what we should be doing to deal with many of the issues that condos have to deal with. So given the fact that we've got these unprecedented times, CCI Huronia wanted to reach out to our members and to the community at large and do something to help them deal with the issues that we are now faced with. And hence we've got this webinar going. In terms of our speakers, I just wanted to introduce everybody. We have Patricia Aaliyah and Ashley Winberg, who are also condominium lawyers. We have Mina Tesseris and Evan Schrolnick, who are both engineers. We have Michelle Farley, who is a fire code safety consultant. And we have Debbie Dale and Jeff Struwig, who are both property managers. So thank you all for joining us today. If you'd like to read more about these individuals, you can go to our website, ccihuronia.com, and click on About CCI and click on Board of Directors. You'll see all of our bios there. In terms of some housekeeping matters, there's a couple things that I wanted to mention. One, we just ask that you be patient with us tonight. This is our first time trying to do this webinar and using this technology and format, and we're all crossing our fingers and hoping it goes smoothly. But if there's any constructive feedback that you have in terms of how we can make this experience better for you, please send an email to admin@ccihuronia.com and let us know if there's something we could do to improve your experience. I'd ask everyone that's on the phone to please mute your phones. And if you're online, please mute yourself and also shut off your camera. This will just make sure that there's little to no interference during this presentation. We are recording it, and we're hoping to have a recording available in a couple days. And so we're just trying to make sure everyone's phones are muted and that you're muted online. Once we have the recording available, we'll be sending an email out to everyone to let them know. In terms of what you're going to hear tonight, I just want to make sure that everybody is aware that this webinar is not professional advice about your specific situation. This is a general discussion and a sharing of ideas about the situation generally. It does not replace the advice of your professionals, and we remind everyone that you should be contacting your professionals about your specific fact situation. Things are changing so quickly today in terms of what's happening with COVID-19, and the advice that you need in terms of your very specific fact situation does need to come from a professional. They are all still working. They're taking calls, emails, they're doing telephone conferencing with clients. So please reach out to your professionals, get an opinion in terms of your specific fact situation, especially if you want to rely on Section 37 of the Condo Act. If you're a director, to protect yourself from liability, you do need to reach out to a professional and get an opinion from them. So just reminding everybody that tonight is not an opinion from the professionals that are presenting. In terms of questions, we're not going to be taking any questions live during the seminar. However, there is a chat function that we have available, and you'll see the chat button in the middle of your screen on the bottom if you're online. Feel free to use that chat function and type in your questions. We'll be monitoring the chat box during the seminar. We'll try and answer questions as we go along, but if we don't, please be aware we're going to hold another meeting next Tuesday, March 31st at 7 p.m. So we'll try to reach those questions then that don't get answered. Also, CCI Huronia is going to be putting together a very special newsletter on COVID-19, and we'll try and answer questions in that newsletter as well that are being raised during these webinars. So without further ado, we've got a very busy agenda ahead of us and lots of topics to discuss. So let's just get started. And the first thing on our agenda is talking about what our condo community is doing right now on the ground. And to talk to us about that, we have Jeff and Debbie, both who are property managers. They're on the ground, they're front lines. So they're going to share what their condo communities are doing. Jeff, can you give us some insight into what your condo communities are doing?
Sure. Thanks, Sonia. So a few weeks ago, as the pandemic started making its way into Ontario, following advice of health professionals, we started trying down amenities like fitness rooms, recreation centers, pools, hot tubs, party rooms, etc. Also arranged for extra cleaning and sanitization of common areas, door handles, elevator buttons, other heavy touch points in the common areas. We also closed our office to the public, maintain minimum staff in the office, and have many staff working remotely. That's to maintain the physical distancing and avoid as much contact with the outside world and so on, so that we can prevent the spread. The other big thing is clear and frequent messaging out to owners, directors, communities in general, service providers. We've been sending out frequent notices to the owners at large, and keeping in frequent contact with boards.
Thanks, Jeff. Debbie, what do you have to add to this?
We're doing a lot of the same things. We've been asking residents to actually stay inside of their suites unless they need to come and go to reduce common area contamination and traffic. We've got some residents that have decided to report in on what their neighbors are or are not doing that they think they should or should not be doing, including tracking these self-isolating groups that have come back from out of the country. Certainly the cleaning services have been keeping us busy. A lot of the owners have had tons of feedback about what we should and should not be cleaning the common areas with. A couple of the properties have developed what I call a buddy system chain. So they're getting together groups within the building that will deliver groceries to the door of residents that are self-isolating. Some are even offering to take out garbage and recycling, wearing gloves. Deliveries have been restricted to the lobbies at most of our properties. Non-essential trades have been discouraged from attending at the site right now. Guest suites and everything like that has been closed. And we've had some interesting innovative thinking. We've got some telephone and email chains going at different properties where residents have written and they've said, here's my consent, please send all my neighbors my email number, my email address, my phone number. And they're getting to calling or emailing each other every day, which has been kind of an interesting thing to watch evolve. Our resident owner forums have become really busy with more activity than usual. A couple of our buildings are using that red paper, green paper thing, where if there's a problem, they'll put up a red paper on the door. Communications have been skyrocketing in terms of volumes. All of our board meetings have been changed to teleconference. Most of our boards just aren't meeting right now because they're too busy. We've canceled all of the upcoming owners meetings in cooperation with board instruction. And we're looking at budgets. You know, what are the costs going to be? When might this be over? Just trying to do some financial planning. And residents are starting to call in asking about how they can pay their condo fees if they're stuck. A couple of our buildings have started a little community pool to pay condo fees for residents that run into some hard times. And one of our boards is developing a COVID-19 Super Achiever Award that they plan on presenting at their AGM when they're able to hold one. So we've had quite a variety of action.
Thanks, Debbie. So you can see from the comments from Debbie and Jeff, there's a wide variety of things that condos are doing. I'm going to pass the mic over to Ashley to address the issue of meetings specifically.
Yes, so the issues of meeting specifically, as Debbie noted, and just with respect to the comments, a lot of the questions, those questions, we're writing them down, and they will be answered in our upcoming newsletter and in the next webinar. In terms of meetings, as Debbie mentioned, it is recommended that all board meetings from now until it is quote unquote safe, or until social distancing is no longer recommended by public health officials, be held by way of teleconference. Now, in terms of owners' meetings, it is also recommended that no owners' meetings be held until public health officials are no longer advocating for social distancing. Now, a lot of corporations have been calling our office and asking, we have our upcoming AGM, what do we do? My recommendation is to not hold your AGM and to postpone it. And this is where it becomes a bit controversial. That would be my recommendation, even if that means you're going to be holding your AGM 6 months after your audited financial statements. This is an unprecedented event. And at this point in time, the safety of the public and everyone at your corporation should take precedence. But again, if you are faced with that issue, it is advised that you seek guidance from your corporation's solicitor. Some boards have been calling our office and have been asking, well, we need a borrowing bylaw pass that we had scheduled, or we're worried we're not going to have quorum. So if it's absolutely necessary that your meeting be held, it can. However, again, I do advise you speak with your corporation solicitor. But if your corporation, for instance, doesn't have quorum for the board, which you do need, you could have a meeting. You do need to have a physical place to actually hold that meeting. However, everyone, with the exception of 2 to 4 people, should be encouraged to attend only by way of proxy, and the meeting should only be for the sole purpose of voting on that matter that must be voted on. So this would mean that you would put a cover letter together with this notice of meeting package saying everyone is urged to attend only by way of proxy by voting on this specific 1 or 2 issues. And then there'd be 2 to 4 people. As little people as possible is ideal. And of course, you'd want those individuals to be 6 feet apart from one another when they're there. You'd have a chair. And that individual could be the individual who is named as the proxy holder in all the proxies submitted. Another individual that could be there could be one of the scrutineers and the recording secretary, and another individual could be just a scrutineer. Ideally, you'd have 4, but it was recently brought to our attention that in New Brunswick, they've prohibited board meetings of 2 or more people, or of more than 2 people. So if you can try and restrict the numbers as much as possible, that is ideal. At the same time, there's nothing right now prohibiting you from distributing your audited financial statements to your owners. However, it is advised that the actual approval of those statements be dealt with at the next in-person owners meeting that you can hold. So if you're doing, if you need to, and if you absolutely need to have an AGM or AGM part 1, then all the other business be addressed at AGM part 2. But it is strongly advised that corporations seek assistance from their legal counsel in this regard, given the requirements under the Act.
Thanks, Ashley.
You're welcome.
Yeah, meetings are a little bit different nowadays until this crisis is over. So we're going to move on to another topic, and we've titled it on the agenda as condos as caregivers, because this is an issue that we see coming up more and more as people are trying to help. And I think it's really important to look at this issue no different than we've looked at this issue in the past. If you've been to any of CCI Huronia's seminars, when we've talked about aging in place or aging issues in condos and dealing with an aging population. And I think it's really important that when you are a director of a condo and you're looking at it from the perspective of a director and from the interest of the condominium corporation, that you're very careful that you don't start creating additional liabilities for the condominium corporation or additional expectations from owners in terms of service that the corporation is going to provide. I know this is probably a message that not everybody wants to hear. But the Good Samaritan, which it's great that we're seeing lots of people privately and as individuals stepping up as Good Samaritans, the role of the Good Samaritan is not really the role that the condominium corporation should be taking on. Because as I just said, it creates liability for the corporation, and you have to remember as directors, you're having to take a look at this as an issue for all owners, not just individual owners. So one issue that has come up is committees, and I think Debbie mentioned some condos creating sort of these committees. I think it's really important from the corporation standpoint that these committees, if they're created organically by owners for owners, that's one thing, but this is not something that the condominium corporation should be creating or endorsing. Again, you don't want the condo corporation to all of a sudden be taking on the responsibility of the caregiver. That's what government is for, that's what health officials are for, that's what families are for and what friends are for, but that's not what the condominium corporation is for. And so I just ask everybody to sort of step back and think about it from that perspective, because as directors, I know we're individuals and we're humans and we want to help, but don't forget you're wearing two different hats. And when you're wearing your hat as a director, you need to think about the corporation and what benefits the corporation. Having said that, I'm going to pass it off to Patricia, because Patricia has some great ideas on how to manage data, but also how to manage interactions in this circumstance. Patricia?
Thanks, Sonia. I would reiterate what Sonia has said in terms of always being aware of what the risk is by expanding our scope of work as directors. I think we have a specific set of roles, but practical realities, face us with how do we manage data really right now in a safe way. And that's one thing that Sonia and I were chatting about. We came up with a list of ideas, which, first of all, I think we should try to have a list of emergency contacts for everybody that's residing in the condominium. We should also perhaps have a list, which we may already have, about which owners require assistance from an outside external party, specifically a caregiver. Why do we want to know about that? We want to know that there are people from outside coming into the condo and need to come into the condo. And the question is, we don't know where they've traveled from, other condominiums, other care facilities in the general area. So what I understand about the virus is that it can travel on clothes and hair. And so we need to be thoughtful about paths of entry, how those are going to be managed. And part of that is knowing who is coming in from the outside. As was stated before, I think, the idea of reducing even the number of people on site is a good first step in managing just generally who's going to be going through our common elements. And then when there are people coming on site, we should have some protocols on managing them when they come on site. We want to know, some of the basic pieces of information, if they've gone outside the country, if they've been exposed to somebody with the virus. These are practical things. But then, further down this, I think it's also important, and we've suggested this in other CCI director seminars, that it can also be helpful to know who has a power of attorney. In Ontario, we have two types, one for personal care and one for property. And both of those are relevant in a condominium when we may have people in suite that are getting ill. You want to know who is actually authorized to make decisions. Now, while we could have caregivers, it doesn't mean that they have necessarily the requisite legal power to make decisions, as well as children or spouses. So it might be good to be proactive in asking people to give you the information around this, all of this being held pursuant to a policy for managing information, which would require that this information, because it's personal to a unit owner, and remain confidential. In addition, I think the other thing that we're seeing now is people are actually being confirmed to have the virus in condominiums. Our objective is to minimize spread. And so one of the things that we're advocating on a certain level is figuring out how to manage that information. Is the board going to ask owners that if you have been diagnosed with this virus, that you disclose that to the board, so then the board can let the community know that somebody has been diagnosed? Of course, everything on a confidential basis, but then asking people to proactively take steps to self-isolate or to think further around how they manage themselves in the common elements. You know, today I think we had actually been asked a question about, or there's a persistent unit owner that wants to know the identity of the person that has the virus. Absolutely not. That's no one's business except that residents or unit owners. They have to take the precautions to self-isolate, and you know, they can work in a confidential way with the board. People do not have the right to know that. Also helping communities, because we don't want to take on too much risk, but there are other resources. Perhaps the board can put together a list of resources that people can contact locally if they're concerned that they may be having the virus, or there are other concerns about caregiving, trying to access resources. This is an effective way to help people help themselves and not step beyond the role of the board. And, you know, these are all sort of fundamental issues. You know, the other unfortunate thing is understanding who to contact in the event of somebody who's residing in the condo. That's different because powers of attorney terminate, of course, upon death. So we want to be able to be proactively using information. We may not need it, but it's sometimes helpful to have it.
Yeah.
Okay.
Please,
So,
please mute your mic, whoever just came on.
okay. And I think that's just generally in terms of managing the data.
Yeah, but it's not her talking.
In terms of data, Patricia,
Yes.
we have some questions about residents, whether they have to inform us, whether they are tested positive, and what can you inform owners if they are confirmed to be tested positive?
Well, I think that's all you could really tell owners, is that somebody in the community has tested positive. If you have the timeline, that's, you know, you have to think about where you are in the timeline as well. But the thing is, because you're not revealing the identity, people don't know whether or not they've crossed paths with this person, right? The objective is to already start to take action, that when you're on the common elements, to manage your own behavior, washing your hands after you use the elevator, for example. But I think it's about that information, but you can't share more than that.
Okay, thanks, Patricia. All right. So we've talked a lot about you know, condo owners and what's happening on the ground. There's a group of people that are involved with condos that we may not necessarily think about right away. And Ashley's going to talk to us about employees and essential workers and how that impacts condos in this day and age. Ashley?
I just wanted to add to Patricia's point. Just personally, my brother-in-law and my father-in-law have been exhibiting mild symptoms of the virus, and they're only testing individuals that have severe symptoms or have an autoimmune disorder or over the age of 65. So we're also recommending to our clients that if any owners, any residents or employees have been exhibiting symptoms, that they also notify the corporation confidentially.
Yeah.
So in terms of employees and the site, last night the Premier issued the list of essential workplace or workers, and essentially anyone who would serve as a condominium corporation is an essential worker. So they are not prohibited from continuing to work as of midnight tonight. They can continue to do so. However, this does not mean that it is business as usual for condominium corporations. Condominium corporations under the Condominium Act, the Occupational Health and Safety Act, and the Occupiers Liability Act have to take reasonable care to protect persons on the property from foreseeable harm, dangerous conditions, and they need to ensure a safe workplace for workers on the property. And that extends to employees directly employed by the condominium corporation, as well as property management staff, cleaning staff that are employees of a third-party company, any trades on site. Essentially, anyone who is doing work and being paid by the corporation to do work on site, this obligation would extend to them. And to some extent, other individuals working within the units while they're on the common elements. So I have 6 principles for corporations to follow in order to take reasonable care in light of COVID-19. The first is to stay informed and to keep yourself updated on COVID-19, as well as the recommendations being made by public health officials and the government, and follow those recommendations. The second is to inform and encourage your employees or anyone on the property to practice proper health protocols like proper hand washing, proper etiquette for sneezing and coughing, and to post these protocols in the common areas. The third, and I know it's difficult to get supplies, but if you can, and really try, please, provide your staff on site with a sufficient amount of masks, gloves, disinfectant wipes, and hand sanitizer. The fourth is to clean and disinfect the areas in which these individuals work numerous times on a daily basis. The fifth, and this is obviously the most important as we're hearing from government officials, is promote and encourage social distancing. This means encouraging your property manager and your potential admin to work remotely if they can. If they need to come into the office or come on site, consider leaving, keeping the property management door closed or only open to residents if they make an appointment in advance and they cannot otherwise communicate what they need to communicate to property management over the phone or via email. Encourage all residents to only communicate with property management and security staff via the phone and email. Whenever there is in-person interaction, advise individuals that they do need to be 6 feet away from one another. If you have a security desk at the entrance of your building, consider potentially taping a perimeter around the desk about 2 feet from where it is in order to ensure that people don't cross that boundary line, and placing a sign at the security desk advising individuals not to cross the boundary. In terms of cleaning staff, if cleaning staff are cleaning a portion of the building, if it is possible, try and block off that portion of the building to restrict resident access. So in order to limit the cleaning staff's interaction with residents when they're cleaning that small area, they can kind of do small areas at a time if possible. And 6, and this is the most important after social distancing in my opinion, implement policies and protocols that comply with the recommendations of public health officials, the law, and the policy should stipulate at a minimum the following. Employees, contractors, anyone that is coming onto your common elements in exchange for money, if they are exhibiting symptoms indicative of COVID-19, that they are to disclose this to their employer. They have an obligation now to disclose this to their employer. If their employer is not the corporation, that individual or company would have an obligation to disclose that to the corporation. And that individual should be instructed to immediately leave the premises and self-isolate for 14 days. And that is if they qualify for a test, if they receive a negative result, okay, come back once they're well. But if they do not qualify for a COVID-19 test, then to remain isolated for 14 days, or as healthcare professionals may otherwise recommend. If any employee or staff member tests positive for COVID-19, they are required by law to notify their employer, and their employer must notify the corporation if the corporation is not the employer. The Ministry of Labor also needs to be notified. Other employees, on-site staff, as well as residents should be notified that someone, and I say someone, don't say resident or employee, someone at the property has tested positive for COVID-19. The same goes for residents. If anyone has tested positive, they do not have a legal obligation to notify the corporation if they're a private resident, but they should be strongly encouraged to do so. And all employees and staff at the property should be notified in writing that someone has tested positive for COVID-19 at the site. And corporations may also want to extend this obligation to individuals who are exhibiting symptoms of COVID-19 but do not qualify for the testing. The other next protocol is any employee who has been in contact with anyone who has been exhibiting symptoms of COVID-19 or has tested positive for COVID-19, they have to self-isolate for 14 days. So if your cleaner's spouse has symptoms of COVID-19, they should be required to disclose that to the corporation and then self-isolate for 14 days.
Babbling away, and I can't.
Thanks, Ash.
All of this will be on our newsletter, but I just want to make one more point, sorry. Employees do have the right to refuse to work if they feel that their work site is not safe. So if there is a resident who has tested positive for COVID-19, an employee does have the right to refuse to work.
Thanks, Ashley. There's some people I'm continuing trying to mute you as we're going through this seminar. Please don't unmute yourself. If I've muted you, just leave it on mute. Thank you. All right, so we're going to now turn to the question of common element fees. And there, I saw one question come up in terms of that. And I hope once I go through my position on this, it'll answer your question about whether you can ask people for proof of loss of income before you defer their common element fees. I want to leave you with 3 words to think about on this issue. And there's a lot of talk about it, and there's a lot of different opinions on this issue. But I want you to think about 3 words: collecting, deferring, and returning. And in terms of those 3 words, your answers are yes, collect, no, don't defer, and no, don't return common element fees. So that's, you know, a nutshell of basically what my position on this is. In terms of returning common element fees, there's been some discussion amongst people and professionals about if you stop offering services or you close down amenities, do you have to return common element fees to the owners because they don't have access? I think the simple answer and the answer that's pretty common among the professionals is no, you don't need to return it. It's no different than someone who says, I don't want to pay for the swimming pool because I don't use it. It's part of the expenses of the corporation. So nobody gets a refund on their common element fees because you've shut down services or amenities. In terms of collecting common element fees, I want everyone to take a step back and take a deep breath and think about this long term. There was an article in the Toronto Star last week about a condo in Toronto who deferred common element fees for 1 month. It sounds great. It sounds like, you know, what a great board of directors. They're looking out for us. But I think it's a very short-sighted solution. We don't know that this situation is only going to be a month. In fact, what we do know is that it's likely going to be much more than a month. So before you even start considering deferring common element fees, which if you ask me, the answer would be don't ever do it. But if you're even considering it, step back and take a look. Do you have enough money in your operating account to be able to even do it? Before you try to figure out how, do you even have enough money in your operating account to do it for 1 month? Because if you do it for one owner, you're going to have to do it for all owners. So can you afford to not receive common element fees for 1 month? And I think probably most condo corporations are going to say no, probably not. And then the question is, if you're going to do it for 1 month, can you do it for 2? Can you do it for 5? Can you do it for 6? And the answer, I'm pretty sure, is going to be no, you can't. Because despite everything that's going on, the condominium corporation is going to continue to incur expenses that need to be paid in order for the condominium to continue to operate. And you need to have that money to be able to pay those expenses. Now, I know people are struggling. some people are not working, but the condominium corporation is not the bank. They're not the government. They're not a social agency. There are other places owners can look to for help if they're not able to pay their common expense fees. But the condominium corporation should not be the one who is basically giving a loan to owners to not pay common expense fees. It's like this big snowball that we're going to run into, is that if we start it for 1 month, it's just going to become worse and worse. So please really, give some good thought to whether you can actually even do it. And then when you think that you can do it, think about the fact that when you defer someone's common element fees, that means other owners are having to pick it up, because at some point somebody's going to have to pay the ongoing expenses.
Recording, so
The other point I wanted to make is that
with no sound.
the other point I wanted to make was that when you're looking at whether or not you can actually do it, you're looking at your operating account, not your reserve fund. You cannot go to your reserve fund to pay your operating expenses. The Condominium Act is very clear. This is not allowed. So again, when you're doing the exercise, you're looking solely at your operating account. In terms of collecting common expense fees, the other issue that's come up is liens. The Ontario government passed legislation that basically froze limitation periods. And some people are talking about, well, now that means that we don't have to lien within the 3 months. And again, my advice is protect the corporation's interests, protect the corporation's priority over mortgages, and make sure you register those liens within 3 months. This is not a time to throw out all the procedures we've had in place that conform with the requirements under the Act. You still need to lien units that are unpaid. The only thing that you might be able to consider once you have actually secured the lien and secured your priority is, and again, this will depend on whether your corporation can even afford to do it, is a payment plan or the delaying of enforcing that lien by power of sale proceedings. Right now, the courts are virtually closed except for emergency matters, so you're not going to be able to take power of sale proceedings at this point in any event. The other thing that I asked you to consider is that your budgets were probably made without COVID-19 in mind, and the extra expenses that are likely to incur as a result of this crisis. So even when you're thinking about whether or not you can do this in terms of deferring common expense fees, remember that if you do have some reserves in your operating account that you could think about using, you might want to think about keeping those reserves for these extra expenses that are going to be coming up over the next couple of weeks or months down the road. The other thing that I just wanted to mention is with respect to common expense fees, don't forget your status certificates, and make sure that you get some professional advice in terms of the wording in your status certificates. There's the section specifically that deals with common expense fees. I also just want to highlight the section with respect to budgets, specifically section 12, paragraph 12. There may be a need for special assessments down the road, something that you haven't contemplated because of the new expenses around COVID-19. So you may want to talk to your lawyer about wording for section 12, just to cover the corporation in terms of special assessments down the road and purchases in this time period. So at the end of the day, collect, yes, collect and lien. Defer, no, not a great idea for condo corporations. Have owners go to other sources to help with their finances. And 3, no returning of condo fees for closed amenities. All right, so I'm going to pass the mic off to Patricia and Mina, who are going to talk about contracts that are in progress right now and contracts that are upcoming.
Patricia, why don't you start? You might have to unmute first.
All right, now I'm unmuted. Okay. Well, okay, I don't mind starting and these are practical considerations that we have to move through. A lot of us have planned capital asset refurbishment projects in the next little while. And I think, first of all, I'm going to say it really depends on what your contract says on what your remedies are. So I would start by reading, talking to your professionals to see what they believe are the sections, that are of concern or give you some rights. With that said, a lot of people in the industry use CCDC contracts. So when I was going through the CCDC contracts, I was thinking about this and just looking at provisions in the template. Usually we like to recommend a CCDC2, so I pulled out a CCDC2. And, and one of the things to think about is that according to the list of essential services that were proclaimed yesterday, a lot of the construction work is considered to be essential, including in residential. Now, I personally think that that was a little bit myopic, and they didn't think of this really narrow subset of condos where we have communities living while construction may be going on. I think they were thinking about really building residential that is empty, or building industrial, or building hospitals. So there might be an adjustment to that in time when there's further reflection done on that. But with that said, I think there are some important provisions in your CCDC 2 contract, for example. Between the health and occupational health and safety requirements and section 3.6 regarding supervision, there is a need to go, and the need to comply with applicable laws. Every condo should be asking a contractor what their COVID-19 procedures are and who is trained in the same and how they're going to be enforced amongst workers on the site. So we always have to remember that the condo hires a GC for the GC to take over. So the general contractor should be the party that is really managing these issues. Section 3.13 under cleanup, it talks about the contractor being required to maintain work areas in a safe and tidy condition. Now, often we thought about this as just physical issues in the sense that, we can't leave tools or debris or areas unsafe. But now, if you think about it more, there's also this concern that if people are doing renovations and let's say a worker's infected and there are hard surfaces, the question is, how are those surfaces being cleaned? Corporations' cleaning staff shouldn't be doing this. Contractor staff should be doing this and managing that issue. With respect to delays, section 6.5.3.4 talks about where the contractor's delay in performance is in the work is occurring. Other than for resulting from a default or a breach by the contractor. In these cases, contract time is extended for such reasonable time as the consultant may recommend in consultation with the contractor, and the extension shall be not less than the time lost as a result of the event causing the delay. Here, for example, the pandemic. In these circumstances, specifically under that clause, the contractor is not entitled to payment for cost incurred during such delays unless such delay is from the acts of the owner, the consultant, or anyone employed or engaged by them. Now, what does that mean? Well, the pandemic wasn't caused by any owner or condominium. But at the same time, we've been talking about instituting protocols. I think it's important in terms of actually managing liability and risk and isolating that, showing that the Condo Corp has actually been proactively managing the risk by having all of its suppliers, including its cleaning contractors, everybody managing within a set of parameters for this virus. Why? Because then the owner has not created any circumstances which would give rise to the delay. And it's really just generally the environment that we're all working in. There are certain circumstances well under Part 7 where their default or termination may be considered for, and this is the thing, I'm looking further into time. Let's say, for example, a contractor is adjudged to be bankrupt or makes a special assignment for the benefit of creditors, which may not be happening right now. It's premature. It might be something that may be applicable in the next 6 to 18 months. So then the owner has a right to terminate the contract. And there are certain steps to be done in order to do that. Again, I mentioned construction safety. Section 9.4 of the CCDC does talk about the sole responsibility for construction safety at the place of work and for compliance is that of the contractor. So OHSA is about protecting workers, creating better and safer work environments, and it will also include managing the spread of disease. Again, this should go back to the contractor, so therefore good discussions about what the protocols are and how they're going to be impacting. Now, here's one other consideration that I read about yesterday, is that most condos have isolated ventilating systems, which is great. So we're not worried about the spread of the disease through our ventilation systems necessarily. But because it can be spread through droplets, when windows are open, and let's say construction is occurring outside the unit, for example, we have condos with balcony repairs going on. Now, while the patio doors aren't open, somebody may open the window. I would make sure that you recommend to all unit owners during the course of construction, even outside, that all these areas are sealed and that they're closed and not open for any purpose whatsoever. So we really limit any transmission at all. That is like an example of where we may go on some of these contracts and some of the provisions under construction contracts that may be of concern. Mina?
Yeah, thanks, Patricia, and hi everyone. I see some familiar names out there, and I hope you're all well and enjoying your self-isolation. The very first point that you made, Patricia, was actually the same point I was going to make. Really, the first step that a condo would want to take if they are in the middle of a contract or have signed a contract is to pull it out and read it, because that contract is going to set out all of the rights and remedies of the parties in terms of suspension, termination, and delay claims. Probably the most common outcome from the pandemic in terms of its impact on construction contracts will be delay claims. And I think what we're probably going to see in terms of a reason for a delay claim will be either a labor shortage. Contractors will claim a labor shortage that's delayed them due to an unforeseen circumstance, or a shortage of materials, and that their suppliers just are unable to supply because their supply chain's been disrupted. And so those are things that if they ever get to the point where there's a claim involved, each party is going to have to dig a little deeper into the cause of those claims and determine whether or not they're an excusable delay or a compensable delay, where there's not just a delay in time, but also a delay that's caused someone to, probably the contractor, to lose money on the contract for which they feel they're entitled to. So that's going to be, I think, where things may be headed once the dust settles over time on the whole issue of the pandemic. But right now, we're more concerned with health and safety of everyone involved, both unit owners and contractors, employees on site, if there's a contract in progress. And as Patricia mentioned, the Ontario government has determined construction in residential settings to be through the directive, it's an essential service, and it hasn't differentiated between occupied residences or new residential construction. And so at this point, we need to proceed on the assumption that it involves all residential construction. Patricia, you mentioned the CCDC2 contract. Parties definitely need to pay special attention to the provisions in their contract. And by and large, that's the form of contract that certainly most constructions, most consultants will use on their projects. And so very important to review the terms of your contract and whether or not there are any special provisions to those contracts that might alter the standard provisions that appear in the template. One thing that we do need to be aware of is what's termed in the legal field the doctrine of frustration, and whether or not an event such as this is causing the contract to be frustrated. In other words, it's just literally impossible to perform the contract due to some circumstance. I don't think we're there yet because of the essential services directive that's been handed down by the provincial government, but it's possible that some other intervening event might compound the issue and cause frustration of a contract. Record keeping, that's another very important point that the condo corporations need to be keeping on top of. Things are changing daily, and it's important to keep track of when government directives are handed down, what the timing is of those directives, and what they involve. How many employees does a contractor have on site? Those sorts of things. What's the change from day to day? Because ultimately, as I mentioned, the delay claims will either be as a result of supply chain issues with materials or labor shortages. So keeping track of how many staff are on site, what the change may be daily is an important thing to note.
Thanks.
Duty to mitigate is just another issue that I think condo corps need to be aware of, and that regardless of whether a contract is frustrated or if there's a delay on the part of either party, usually the contractor in this case, there is a duty on the part of both the contractor and the owner, so both parties of the contract, to take all reasonable steps to recover any losses or prevent any additional losses with regard to the contract. So people need to they have a duty to act in good faith and mitigate their losses.
Mina, I'm gonna cut you in here because I'm just looking at the time, and we're slowly running out of time. Do you have like one last point you want to make on this topic?
I have lots of points, but I think we need to move on, Sonia.
Okay, thanks. Sorry for cutting you off. Michelle, you were going to give us a brief update in terms of how does this all play with respect to the fire code.
Thank you very much, Sonia. I was happy to hear a few people mention the law, and the fire code is the law and it is life safety. So even though we're all talking about health and safety right now, the fire code requires that owners maintain all of their life safety systems within their buildings, and that includes throughout these challenging times. And that includes fire routes, fire alarms, sprinklers, standpipe systems, but even buildings that just have smoke alarms, CO detectors. The owner's obligation is to comply with the fire code, and the owner under the fire code is any person who has care and control over the condo, directors, managers. It's mandatory to include and complete compliance under daily, weekly, and monthly annual requirements. The Fire Marshal's office, who I've been reaching out to looking for a statement, I received something at 8:46 this morning that basically said that they have had to implement some communication protocols. It's developing situations, and their internal communications will respond. So the bottom line is it's a law, and they're not putting anything in writing right now. Our local fire departments have differing perspectives. Some have staffing level issues and are not doing anything other than urgent situations. Others are continuing to do regular inspections. If you are under order, you are required to continue to comply we are getting just as many calls from property managers saying, do I have to do this, as we are from fire departments saying, when's your engineer coming out to assess the fire separation that is a subject to this fire investigation. So the bottom line is we're expected to comply with the fire code. The Canadian Fire Alarm Association, who pretty much covers most of the life safety system inspections as they're required to be done by a qualified and trained person, has stated that they are a safety essential workplace service. They've publicized that out to all of their contractors. I've spoken to some contractors that are, partially standing down. Many others are looking to get into the buildings safely. But what does this mean to your condominium corporation? The best thing is to do what you can best do within your ability. So consider your corporation situation, whether you're exposed to the virus or not, what measures are being put in place for that, what access your contractors are going to need. Do you have supervisory staff available? You have to maintain those life safety systems, so you have to do your best to do that. And as Mina said, you have to keep good records. If the fire department shows up in 6 months and wants to see all your records of all your daily, weekly, and monthly and annual inspections over the last 6 months, you have to have them, whether they were completed by your service company or by your property manager, somebody on the board. So the best thing you can do at this point is review your fire safety plan responsibilities or your fire safety plan documents if you have a condominium townhouse where maybe you have differing responsibilities because you just have CO detectors and smoke alarms. But if you have any fire doors in your building, somebody's supposed to be checking those monthly. They may have been your cleaner, and I've heard from some property managers or cleaners are not coming out right now. So will yesterday's announcement change things? We're not sure, but there are contractors out there that are available to work. You need to develop a compliance action plan. Start with your fire safety plan, talk to your property manager, talk to your consultants. You might need help developing a plan. Certainly, I know we're offering a lot of virtual support right now, including helping people to determine how that contractor can get on site to do that contract. Some are for unsafe conditions. We've had engineers witnessing flow tests, for example, where there's a problem on a system, so that we can actually do some virtual reviewing of different systems. So the main thing is you are obligated to comply. Find the best way to do it within your building under your individual circumstances. And this, of all times, is the most critical time to be fire safe. So review what you have to do, what your obligations are, and take all reasonable means to continue to comply with the fire code.
Thanks, Michelle. Thanks, Michelle. All right, so we're coming up to 8 o'clock. Evan and Patricia, in 2 minutes or less.
Evan.
Yeah,
what can you tell us about Tarion? And we may have to carry this conversation over to next week's webinar as well. We're also going to carry over the how communities are communicating over to next week's seminar. So Evan, take it away. You've got the last 2 minutes.
I'll keep this to a minute or less. With the Tarion, our concern as an engineer is making sure that the condo corp is preserved, their rights are preserved. And with the Tarion, there's a concern that we can't do a full inspection. There's certain areas that we might not be able to access and be able to provide our full service. And if we're not providing our full service, we might not be identifying all the deficiencies that should be warranted under the Tarion. So our simple recommendation right now is Tarion has said that they will review any extensions required in order to do inspections on a case-by-case basis. We've had a couple that we've issued and we've gotten 30-day notices. So my recommendation to any condo board that is going through the performance audit process, there's a lot of key dates. There's too many for me to name right now. These dates, if they're in question, you should be working with your engineer and looking at what they can do. Are they providing the full service? If they can't, requesting an extension on that service through Tarion. We have to do that request that for every date for each individual condominium corporation. Beyond that, what we always recommend is if we disagree with some of what the Tarion is saying right now and not postponing all dates or suspending some of those dates, The Ontario caucus is putting the CCI caucus is getting together and putting something together for the provincial government to look at. But until such time, your engineer or whoever is the declarant, could be the condo board property manager, should be requesting, identifying if any of the dates are in question and requesting the Victorian, the extension. And there's right on the website of Victorian, there's a home an email address for each condo board to be able to send these questions to, or the request for extensions.
Thanks, Evan. Patricia, did you have a quick comment on that, or you want to leave it till next week?
No, I think it's fine till next week. It's all good. Thanks, Evan.
Okay. All right. Well, we're now at 8:01. I promised that we were going to keep this to a 1-hour session. So thank you, everyone. We've got people from across the province on this call, so that's great. And we look forward to seeing everyone next Tuesday at 7 o'clock. Information is going to be going out tomorrow with respect to the next webinar. And also just wanted to give everybody a little heads up and a teaser. CCI Legislative Committee at the national level is working on some legislative changes that they want to propose to the government in light of COVID-19. Patricia Lee is one of the people on that committee. So on our next session, we are going to actually be talking about some of the legislative changes that CCI Huronia, CCI is advocating for on behalf of all condo owners. So we'll see you next week. Everyone, please stay safe, practice social distancing, and we're all going to get through this one way or another. And together as a community, we're just going to be stronger for it. So we'll see you next week. And thank you to all the speakers, and thanks to everyone on the line.